The Articles of Confederation and the Constitution by Amanda and Kira.
The Articles of Confederation. The Articles of Confederation is considered the original Constitution of the United States. It was created on November 15, 1777. It was ratified in 1781, and the need for a stronger federal government was resolved when the present United States Constitution replaced it on March 4, 1789.
There are a small handful of strengths for the national government due to the Articles of Confederation. It had the power to declare war and make peace, power to coin and borrow money, sign treaties with foreign countries, and operate post offices.
There were a lot of weaknesses, like it lost confederation of sovereign states and a weak central government, leaving most of the power with the state governments. It could not force states to obey its laws. It had no power to tax, no power to enforce laws, and Congress lacked a strong and steady leadership.
More weaknesses were no national army or navy, no system of national courts, no national currency.
States had the ability to levy taxes, enforce laws, create their own laws. Each state could issue its own paper money, and each state could put a tax on goods coming in from another state or country on trade between states.
The Constitutional Congress of 1787 was created to amend the Articles of Confederation. There were 55 delegates from all over the countries, and these delegates met in Philadelphia.
Some people present at the convention were George Washington, James Madison, George Mason, William Patterson, and Governor Morris.
At the Congress, they discussed the Three-Fifths Compromise, the Virginia Plan, the New Jersey Plan, and the Connecticut Compromise.
The Virginia Plan was created by James Madison. It was a detailed plan for a new government that essentially got rid of the Articles of Confederation completely.
The Virginia Plan was a new proposal for a national government. It had the power to make laws and taxation. It was a bicameral or divided government.
It separated into legislative, executive, and judicial branches. Congress would be separated into two houses. People in the second house were voted in by the first house, but chosen by the state.
The number of representatives were determined by the population of the state, which meant more people in the state meant more power to the state, which was a problem for smaller states.
The New Jersey Plan was written because smaller states did not want bigger states to outvote them. William Patterson proposed it.
It modified the Articles of Confederation. It had Congress as one house, and each state was equally represented. Congress also had the power to raise taxes and regulate trade.
The Connecticut Compromise. It was a compromise between the New Jersey and Virginia plans. Roger Sherman from Connecticut suggested it.
And this is a lovely picture of Roger Sherman, placed by Amanda.
It proposed that in one house of Congress, representation would be based on population, and the Senate would have equal representation.
Voters elected representatives, and state legislators were chosen.
The Three-Fifths Compromise. It was a compromise between northern delegates and southern delegates. The debate was on whether slaves would be counted towards total population, and it also stated that there could not be high taxes on slaves.
The Constitution of the United States is the supreme law of the United States of America. It was completely ratified in 1790. This happened due to the ineffectiveness of the Articles of Confederation.
It was originally compromised of 7 articles. Hold on.
Voters elected representatives, and state legislators chose senators.
The Three-Fifths Compromise was a compromise between northern delegates and southern delegates. The debate was on whether slaves would be counted towards total population, and it could not impose high taxes on slaves.
The Constitution of the United States is the supreme law of the United States of America. It was completely ratified in 1790. This happened due to the ineffectiveness of the Articles of Confederation.
Originally compromised of 7 articles, delineates the national frame of government, creates 3 branches of government. This is called separation of powers. These branches have delegated/enumerated powers which is a political power specifically delegated to a governmental branch by a constitution.
The first branch is the legislative branch, which is a part of the United States government that creates laws. It is made up of the Congress and Senate. The House of Representatives is the lower house in the United States Congress. With 435 populated elected officials, House seats are appointed relative to each state's population. The Senate is the smaller upper assembly in the U.S. Congress, part of the legislative branch. There are 2 delegates from each state. The Elastic Clause is a statement in the U.S. Constitution granting Congress the power to pass all laws necessary and proper for carrying out the enumerated list of powers. The Congress decides on a bill, which is a starting place of laws. These laws, once accepted, then turn into laws. These bills, once accepted, then turn into laws.
The second branch, the executive branch, is broadly responsible for implementing, supporting, and enforcing the laws made by the legislative branch and interpreted by the judicial branch. The president is the elective head of a republic, elected by the citizens of the nation. A cabinet is a body of advisors to the president composed of the heads of the executive departments.
The third branch is the judicial branch, which is the part of the U.S. government that interprets law and administers justice. The judicial review is the law where legislative and executive actions are reviewed by members of this branch. A court with judicial members view government laws and decisions to see if it follows the Constitution.
To ensure that each section of the government does not abuse their power, the rule of checks and balances was in place. This rule was put into action to counterbalance influences of one branch to ensure that political power is not concentrated in the hands of a certain group or individual person.
This form of government is considered a federalistic republic. A republic is a state where supreme power is held by the people. These people elect individuals to represent them in the government. The federal system of government is when there are 2 or more levels of government that are governed by shared powers such as a constitution.
The Federalist Paper was first written anonymously by a group of Federalist journalists. It promoted the ratification of the Constitution and was a collection of 85 articles and essays.
The actual authors were Alexander Hamilton, James Madison, and John Jay.
The Land Ordinance of 1785. It was passed by Congress. It allowed the sale of land in the Northwest Territory, and some standards that are still used today are things like the selling of land in square mile sections.
The Northwest Ordinance. It was enacted by Congress, established orderly and equitable procedures for the settlement and political incorporation of the Northwest.
Ratification. The first conventions took place in December of 1787. Delaware, Pennsylvania, New Jersey, Georgia, and Connecticut ratified immediately.
The debate in Massachusetts took place in 1788. It was comprised of mostly anti-Federalists, including John Hancock and Samuel Adams. The Federalists promised to attach a Bill of Rights after this debate.
The Federalists, in an effort to get the Anti-Federalists to ratify the Constitution, promised a Bill of Rights, and then the debates slowly came to compromises and the Constitution was ratified.
It was finally ratified in 1790. Rhode Island was the last state to ratify. Yay!
The Bill of Rights was put into place to guarantee fundamental individual rights. Most important acts of the new Congress was promised by the Federalists, and James Madison was the drafter.
Congress agreed on 12 amendments, but the states only passed 10. These 10 went into effect and are referred to as the Bill of Rights.
The first 8 protect the rights of individual people from the federal government. The 9th Amendment states that people have other rights that are not listed, and the 10th Amendment states any powers not specifically given to the federal government are given to the states and or people.
This is Eric. He has nothing to do with this. Thank you.